All right, we should be live. Hello, everyone. Welcome. Good afternoon. I'm Leonard French, your favorite copyright attorney, and we have another epic response or opinion or decision in one of the election lawsuits. This is the lawsuit between Dominion Voting Systems and Sidney Powell, Rudy Guiliani, and Mike Lindell / MyPillow. It is long, so I've highlighted out the parts that I want to read. That'll be on your screen, and we're just going to go over maybe half of the document. When we get to the part about jurisdiction and the proper venue, those topics of law get really complicated, and it would kind of make... It's kind of the boring part, so we're going to skip the boring part, and instead we're going to let the judge tell you what's going on here. I'm going to throw my opinion and reaction in a little bit, but this will mostly be directly from the document. To give you a little bit of a background, my opinion of the election lawsuits is that they've all proven to be baseless. It's one thing to challenge a action, election, contract, whatever, with evidence. It's another thing to do so without evidence. I'd be among the people who would be outraged if there actually was evidence of massive election fraud, and I would want it to be corrected, and whoever was supposed to win without the election fraud would win. But no one has been able to show that evidence, and there's been many, many court cases, well over 100 court cases, where the evidence should have been presented. You don't withhold evidence. There is no secret gotcha in court. You disclose the evidence that you have, and you are allowed to proceed forward with your case. So this is going to be the motion to dismiss that Sidney Powell, Rudy Guiliani, and Mike Lindell / MyPillow had filed against Dominion's complaint, seeking about, I think it's 1.2 billion, 1.3 billion, 626 million in damages, and then another doubling of that for punitive damages. So the judge is going to do a better job than I could summarizing everything from here, so we're just going to jump into it. This is in the United States District Court for Washington, D.C., and it's three separate cases, Dominion v. Sidney Powell, Rudolph Giuliani, and MyPillow. And the judge writes, U.S. Dominion, Inc. and other related corporate entities sued three sets of defendants, Sidney Powell, her law firm, and a related entity, Rudy Giuliani, separately, and Mike Lindell and his company, MyPillow, alleging that they each defamed Dominion in connection with the 2020 presidential election. The defendants have since moved the court to dismiss all of Dominion's claims for the following reasons. The court denies their motions in full. The most recent presidential election occurred on November 3rd, 2020. While many Americans cast their votes that day, others did not. Some voted in person before November 3rd, and others sent their ballots by mail. States employed a myriad of procedures to handle early and mail-in votes. Some started counting in the days or weeks leading up to the election, while others waited until election day itself. Real quick, in case anybody's wondering why different procedures were allowed in different states, is that they are. The states have their own sovereignty within the United States, and the way the United States is structured, the states do have control over the how of voting within some rules and guidelines set by the Constitution, due process, federal law and regulation. But otherwise, the states and sometimes the counties in the state can have slightly varying rules. Maybe somebody has 7 days of early voting, maybe somebody has 10 days, maybe somebody has a 3-day correction period. Some counties in Pennsylvania had no correction period if your ballot was rejected for some reason. So those were legitimate disputes. And in most of the election cases that challenged those things, the judges said, you waited way too long. You can challenge those things, say, 6 months before the election, but not 4 weeks after the election or 2 weeks after the election. But that's not what we're here about. We're here about this defamation suit. Even 24 hours after the polls closed, no clear winner had emerged. Several news outlets projected 253 electoral votes for now President Biden and 213 for then President Trump. But the outcome of the election depended on 6 states, Georgia, Pennsylvania, Nevada, North Carolina, Alaska, and Arizona, whose results were not finalized until much later. On November 7th, various news outlets declared Joe Biden the winner, but public controversy surrounding the election was far from over. Election results in various states were challenged, audited, and eventually certified over the course of the next several weeks. They go into the parties here, and we know who the parties are, but I did want to point out that Sidney Powell is an attorney, former federal prosecutor, and media figure, and when they refer to DTR, that's her company, Defending the Republic. Giuliani is also an attorney, or we don't know how much longer he'll be an attorney. He is currently suspended pending a full adjudication of his status of his license. So that's happening. We have a video on that. He served as mayor of New York City, Associate Attorney General of the United States Attorney for the Southern District of New York, and Mike Lindell is the founder and CEO of MyPillow. Dominion alleges that each defendant made defamatory statements about its role in the 2020 election. Those statements are too numerous to summarize in their entirety, so the court is going to limit its discussion to the allegations necessary to decide the pending motions. So I also am going to limit it a little bit. There's a whole section about all the statements, and then the judge is going to repeat a lot of the statements when evaluating their veracity or their ability to be facts versus opinion. So we're going to read maybe a page or two of these, and then I'm going to skip and let the court tell you what the court thinks. On the day of the presidential election, Powell appeared on One America News Network and declared that Democrats were trying to steal the vote from President Trump and that they had developed a computer system to alter votes electronically. Shortly thereafter, she and Giuliani visited Trump campaign headquarters, where they both urged the campaign's attorneys to cast doubts on election results by focusing suspicion on Dominion. The campaign declined to pursue those claims after Powell was unable to provide it with supporting evidence. Between November 3rd and December 23rd, both Powell and Giuliani appeared on various television shows in which they stated that Dominion was connected to Venezuela. In particular, on November 12th, Giuliani appeared on Fox Business's Lou Dobbs Tonight and stated that Dominion is owned by a company called Smartmatic, which Giuliani claimed was formed by 3 Venezuelans, quote, in order to fix elections. Powell was a guest on the show the next day. She stated she could hardly wait to put forth all the evidence we've collected on Dominion, starting with the fact it was created to produce altered voting results in Venezuela for Hugo Chavez and then shipped internationally to manipulate votes for purchase in other countries, including this one, end quote. Do keep in mind, she said starting with the fact. So that's going to come into this when we start evaluating facts versus opinions. On November 15th, Powell appeared on Fox News' Sunday Morning Futures. She stated that Dominion was involved in a massive election fraud and that she had evidence of substantial sums of money being given to family members of state officials who bought Dominion software. 2 days later, she appeared on Newsmax's Greg Kelly Reports and said, "We've got the evidence," from the mouth of the guy who founded the company. "I haven't had a chance to get that out to the public yet. The founder of Dominion admits he can change 1 million votes, no problem at all." Powell promised that she would tweet out the video later and tag the host in it. She has not disclosed the video. On November 19th, Giuliani and Powell appeared together at a press conference at Republican National Committee headquarters in Washington, D.C. At that press conference, Giuliani stated that they represented President Trump and the Trump campaign, and Powell repeated her claims about Dominion being a tool created to make sure Hugo Chavez never lost an election and imported to the United States to flip votes from Trump to Biden in the 2020 election. She stated that the legal team had collected testimony of different workers admitting how they were trained to dispose of Trump votes and add to Biden votes. The software has a feature pursuant to which you can drag and drop any number of batches of votes to the candidate of your choice or simply throw them away. So we have mathematical evidence in a number of states of massive quantities of Trump votes being trashed. Just simply put in the trash like you would on your computer with any file, and with Biden votes being injected. President Trump later sent a tweet including video footage of that press conference. After a hand recount, Georgia certified its election results on November 20th. That same day, Powell appeared on the Examining Politics podcast and stated that Dominion paid kickbacks and benefits to families of public officials who got Dominion its government contracts. One day later, she appeared on Newsmax and elaborated that Georgia state officials were in on this Dominion scam with their last-minute purchase of a contract to Dominion of $100 million. On November 23rd, Powell again claimed that Dominion had stolen Trump votes by massive election fraud and that she was collecting overwhelming evidence that Dominion shifted millions of votes from President Trump, and that Dominion was founded by foreign oligarchs and dictators to ensure computerized ballot stuffing and vote manipulation to whatever level was needed to make sure Venezuelan dictator Hugo Chavez never lost another election. And here's where I'm going to skip ahead a little bit. So there's a lot more allegations, but the judge is going to repeat many of them here. So I've skipped now to defendants' claims. In addition to making the statements summarized above, Powell, Giuliani, and Lindell all stated that they had evidence to prove their claims. For example, Powell has stated that she is in possession of a video that depicts the founder of Dominion saying that he can change 1 million votes no problem at all. She has also pointed to documents filed in her election lawsuits, including an undated certificate from the Georgia Secretary of State, declarations, which are kind of like affidavits, but declarations under federal law don't need to be made before a notary, but they're still under penalty of perjury. Declarations from an anonymous military intelligence expert, quote, and Venezuelan military officer, research into general concerns about election security, and expert reports, one of which Giuliani also touted in his podcasts. Lindell claimed that the blog, his blog, or the American Report blog, contained pages of the machine voter fraud evidence that came out last week. He also tweeted a screenshot to an American Report spreadsheet that he said was one of hundreds of pages that proved President Trump got around 79 million votes to 68 million votes for Biden. And on February 4th, Lindell appeared on the Flashpoint podcast or program and claimed that he had a cyber footprint from inside the Dominion machines, proving that the machines were hacked by foreign countries, starting with China. Lindell later included this same material in a 2-hour documentary called, in full caps, Absolute Proof. The video also suggested that then Attorney General Bill Barr, who had stated that the Department of Justice had not seen evidence of widespread election fraud, was corrupt and had been compromised. Beginning on February 5th, Absolute Proof was broadcast on multiple news outlets and posted online. Lindell's website also posted the video. Beneath it, a MyPillow ad encouraged viewers to use the promotional code PROOF to receive 40% off a MyPillow product. On January 8th, Dominion filed a lawsuit against Powell, her law firm, and DTR for defamation and deceptive trade practices. A month later, Dominion filed a similar suit against Lindell and MyPillow. It also separately sued Giuliani on a single count of defamation. In all 3 lawsuits, Dominion alleges that the defendants' conduct caused 1. Dominion employees to be stalked, harassed, and receive death threats, requiring Dominion to expend money to remedy the defamation and to protect the lives of its employees, and 2. Harm in the form of lost profits and damage to its name, reputation, and goodwill. Dominion alleges that it has suffered at least $651,735,000 in damages. Dominion also seeks a doubling of that in punitive damages, costs, and fees. And with respect to Powell and Lindell, a narrowly tailored permanent injunction requiring the removal of their defamatory statements and enjoining them from repeating such statements. All defendants move to dismiss, but make different arguments. The Powell defendants argue that this court cannot exercise personal jurisdiction over them, that the claims against them should be transferred to Texas, and that Dominion has failed to state its defamation claim because Powell's statements are only statements of opinion, not fact, and Dominion has failed to plead actual malice. So that's the first piece of damning response from Powell, in my opinion. She goes with the standard defamation defense that what she was saying was opinion and that no reasonable person would interpret what she was saying as fact. She literally used the word fact, and she says, we have evidence and proof. The judge is going to go over this, so I'm not going to ramble on for too long, but it does seem telling to me that someone would come forward with lawsuits and claims and say that things are facts, and then the moment they're challenged on it, they say, oh, no, that's just my opinion. The Powell defendants also seek dismissal of Dominion's deceptive trade practices claim on the grounds that they were not engaged in trade or commerce of goods. Lindell and MyPillow filed separate motions to dismiss. Lindell argues that he is not the subject of the court's personal jurisdiction. Venue is improper. Dominion has failed to state a defamation claim because his statements are protected as debate on public issues, and because Dominion has failed to plead actual malice. We'll go over actual malice in a moment. That's why I'm not going over it now. MyPillow joins these arguments, but also contends the claims against it must be dismissed because it hasn't made any statements about Dominion. Both defendants also argue that Dominion's deceptive trade practice claim must be dismissed because it merely recasts the defamation claim. Guiliani argues only that the defamation claim against him should be dismissed because Dominion may only recover lost profits as special damages, which Dominion has failed to plead. So the judge now starts in on the legal standard. We're going to cover just a couple sentences of this. So we're here on a motion to dismiss standard under Federal Rule of Civil Procedure 12b-6. Law students will get to know Federal Rule of Civil Procedure 12b pretty well, pretty detailed, because that's going to be something that's on the bar exam, or could be on the bar exam. In a motion to dismiss under 12b-6, failure to state a claim is the shorthand for that. The court must treat the complaint's factual allegations as true and must grant plaintiff the benefit of all inferences that can be derived from the facts alleged. So if there's a fact that can go either way, they're going to favor the plaintiff. This is not a final decision in the trial or something like that. This is the start of the lawsuit, and the defendants have challenged the ability of the lawsuit to even start to go forward. So this is a major hurdle that the plaintiff has to clear before the court will then open the lawsuit for its initial hearings, initial disclosures of evidence, the answer to the plaintiff's claims by the defendants, to discovery of relevant evidence going in both directions. So if the plaintiff can clear the motion to dismiss hurdle, then that's when the real lawsuit starts. Instead of just being a pleading, which has not been proven yet, now we're going to get to see the proof as this unfolds. Factual allegations must be enough to raise a right to relief above a speculative level. While a complaint does not need detailed factual allegations, a plaintiff's obligation to provide the grounds of its entitlement to relief requires more than just labels and conclusions, or a formulaic recitation of the elements of a cause of action. The claim to relief must be plausible, and plaintiff's pleadings must nudge the claims across the line from conceivable to plausible. This is now to the analysis of the statements. Are they fact or opinion? This is going to be the good part. So strap yourself in. If you can't strap yourself in, get a Frontier flight attendant to do it for you, and grab your popcorn before you do that. Powell alone argues that her statements cannot be defamatory because no reasonable person could conclude that they were statements of fact. That just speaks for itself. No reasonable person could conclude that Powell was speaking statements of fact. That makes absolutely no sense. She literally said, this is a fact. In one of her statements, she said she has evidence and proof. Let's see what the judge has to say. For a statement to be actionable as defamatory, it must at least express or imply a verifiably false fact about the plaintiff. And while statements of opinion regarding matters of public concern cannot be defamatory if they do not contain or imply a provably false fact, they are actionable if they imply a provably false fact or rely upon stated facts that are provably false. In deciding whether a reasonable fact finder is the jury or the judge in a bench trial, but I'm going to guess this kind of thing would go to a jury, or maybe summary judgment. You might not get to a trial or an adjudication in a trial, in a live trial, because Dominion might be able to have enough undisputed evidence that they can have the judge adjudicate the matter on the papers alone, on the record alone. The docket is the record that the court uses. The fact finder could conclude that a statement expressed or implied a verifiably false fact about the plaintiff, and the court must consider the statement in its context. Powell contends that no reasonable person could conclude that her statements were statements of fact, because they concerned the 2020 presidential election, which was bitter and controversial. Bitter and controversial are not parts of defamation law. I can guess that you could characterize something that is part of the law along with adding context that it was bitter and controversial, but I'm not seeing how that helps her in any way. And were made as an attorney advocate for Powell's preferred candidate and in support of her legal and political positions. Just being someone's attorney does not mean that you can defame someone, or you can commit the act of defamation and not be later held liable for it. There is some protection for when an attorney files a court pleading, but statements made outside the court pleading can still be defamatory. And that the defamatory statements in a court pleading, that's not necessarily absolute immunity. It can be what's called the litigation privilege, but that's not what she's arguing here. These statements were made outside of court. As an initial matter, there is no blanket immunity for statements that are political in nature. As the Court of Appeals has put it, the fact that statements were made in a political context does not indiscriminately immunize every statement contained therein. It is true that courts recognize the value in some level of imaginative expression or rhetorical hyperbole in public debate, but it is simply not the law that provably false statements cannot be actionable if made in the context of an election. MyPillow appears to similarly argue that the First Amendment grants some kind of blanket protection to statements about public debate in a public forum. Again, there is no such immunity. Powell similarly argues that her statements were protected commentary about other lawsuits, but Powell cannot shield herself from liability for her widely disseminated out-of-court statements by casting them as protected statements about in-court litigation. An attorney's out-of-court statements to the public can be actionable, even if those statements concern contemplated or ongoing litigation. The question then is whether a reasonable juror could conclude that Powell's statements expressed or implied a verifiably false fact about Dominion. This is not a close call. To take one example, Powell has stated publicly that she has evidence from the mouth of the guy who founded Dominion admitting that he can change 1 million votes. No problem at all. She told audiences that she would tweet out the video. These statements are either true or they are not. Either Powell has a video depicting the founder of Dominion saying he can change 1 million votes, or she does not. To take another example, Powell has stated that she could hardly wait to put forth all the evidence on Dominion, starting with the fact that it was created to produce altered voting results in Venezuela for Hugo Chavez. Again, this statement is either true or it is not. Either Dominion was created to produce altered voting results in Venezuela for Hugo Chavez, or, as Dominion alleges, it was not. The Venezuelan theory presumably finds its roots in the Venezuelan origins of Smartmatic, a different company that Giuliani alleges owns Dominion, but that Dominion alleges is its competitor with no connection, either through ownership or through software. No connection with Dominion. And as far as I've been able to find, Dominion and Smartmatic are two separate companies that provide voting machines to completely separate areas. Nobody, as far as I can tell, as far as my research, my light research on that particular fact, I have not seen anybody who hired Dominion and Smartmatic to provide voting machines for the same precinct. Usually you choose one vendor or the other, and they're not the same. Let's find where I left off. Take a few more examples. Powell has stated publicly that Dominion flipped, weighted, or injected votes during the 2020 election. Either Dominion did so or it did not. Powell has claimed that state officials received kickbacks in exchange for using Dominion machines. Either state officials received such kickbacks or, as Dominion alleges, they did not. All of those statements and many others alleged in Dominion's complaint expressed or implied a verifiably false fact about Dominion. Powell argues that these statements are merely her own interpretation of underlying facts that have been disclosed. Statements may not be actionable if the defendant provides the facts underlying the challenged statements. Truth of a fact is always a defense to defamation. And it is clear that the challenged statements represent her own interpretation of those facts, leaving the reader free to draw their own conclusions. But, the court says, with respect to many of Powell's allegedly defamatory statements, Dominion alleges, and this is a motion to dismiss, the court must accept as true, that she lied about having, or at the very least has not disclosed, her purported underlying facts. For example, Powell has stated that she has evidence from the mouth of the guy who founded Dominion admitting that he can change 1 million votes. No problem at all. She has not, however, disclosed that video. She has also claimed that Dominion paid kickbacks to the families of Georgia public officials, but the only evidence to which she points in support of this claim is an undated and allegedly doctored Georgia state certificate stating that Dominion's systems had been thoroughly examined and tested and found to be in compliance with Georgia law. That certificate provides no evidence of illicit payments to public officials' families. It is certainly not, as Powell has argued, quote, evidence from various whistleblowers that are aware of substantial sums of money being given to family members of state officials who bought this software, $100 million packages for new voting machines, suddenly in multiple states, and benefits ranging from financial benefits for family members to sort of what I call election insurance, because they know that they can win the election if they are using that software. In sum, Dominion has adequately alleged that Powell made a number of statements that are actionable because a reasonable juror could conclude that they were either statements of fact or statements of opinion that implied or relied upon facts that are provably false. On to the actual malice requirement. Powell and Lindell both argue that Dominion has failed to allege that they made their defamatory statements with actual malice. That is, with knowledge that they were false or with a reckless disregard for whether they were false or not. We usually refer to this as red flag knowledge. Did you know, should you have known, or did you have a willful blindness or willful disregard for the knowledge? You intentionally avoided knowing something you should have known in order to be able to say, oh, I don't know, I never looked. A defendant acts in reckless disregard of the truth if she, in fact, entertained serious doubts as to the truth of its publication or acted with a high degree of awareness of probable falsity. The serious doubt standard requires a showing of subjective doubts by the defendant. Subjective doubt can be proven through the accumulation of circumstantial evidence and also direct evidence demonstrating that the defendant was subjectively aware it was highly probable that its story was fabricated, so inherently probable that a reckless person would have put it in circulation, or only a reckless person would have put it in circulation, or based wholly on an unverified anonymous telephone call or some other source that the defendant had obvious reasons to doubt. So that's a pretty high standard. That's a subjective standard. So you're allowed to be wrong about it as long as you genuinely, we say good faith belief in copyright law. She could just have a good faith belief, but it has to be good faith. It has to be sincere. It can't be something where you should have been able to find the truth or falsity of it, and if you just looked even a little bit, and the court's going to deal with that now. Dominion argues that it has cleared this high bar. As to Powell, Dominion contends it has alleged not only that Powell's claims are so inherently improbable that only a reckless person could have believed them, but also that she deliberately ignored the truth in favor of relying on facially unreliable sources, sources that are unreliable on their outside. You don't even have to dig to figure it out. That she intentionally lied about and fabricated evidence to support a preconceived narrative about election fraud, and she did so to raise her own public profile and to make a profit. Powell's primary argument is that she could not have entertained serious doubts as to the truth or acted with a high degree of awareness of the probable falsity of her claims because she relied on sworn declarations and other evidence that supported her statement. But there is no rule that a defendant cannot act in reckless disregard of the truth when relying on sworn affidavits, especially sworn affidavits that the defendant had a role in creating. And Dominion alleges that Powell's evidence was either falsified by Powell herself, misrepresented and cherry-picked, or so obviously unreliable that Powell had to have known it was false or had acted with reckless disregard for the truth. Powell again faces an obvious hurdle in the fact that she has never produced nor mentioned in any sworn affidavit the video of Dominion's founder that she claims to possess. A reasonable juror could conclude that Powell has not produced the video because she doesn't have it. We call this an adverse inference. The facts that you're saying you have, the evidence that you're saying you have, would exonerate you if you produced it, but you're not producing it because it doesn't exonerate you. And if you don't testify in a civil case where you're required to testify, if you don't turn over evidence in the initial disclosures or during a discovery request or something, the opposing side can ask for the court to infer that what you're not turning over is adverse to you. So the short legal way of saying that is an adverse inference. The court is saying here, she could simply produce the video and put this to rest, but she hasn't done that. So she's either waiting until August of 2021, 9 months after the election, or she doesn't have it. Why she would wait, why a trained and licensed attorney would wait to produce the evidence that proves her claim, she doesn't have it. That's the only inference I can make. And the court agrees here. Or should I say, I agree with the court. Dominion also alleges that Powell doctored a certificate from the Georgia Secretary of State, which, if true, would be some kind of falsification of evidence. And that's a pretty big charge, although that's just going to be part of defamation here. I don't think there's a separate claim for that in this case. It is alleged that she doctored the certificate to make it appear as though Georgia officials purchased Dominion machines and software on a rushed timeline. The certificate is publicly available on the Georgia Secretary of State's website, and it includes the state's date, the Secretary of State's date, seal, and signature, but Powell claimed that the Dominion certification was undated and filed a copy of the certificate that was missing the date, seal, and signature during the course of her election litigation in Georgia. And the only thing I can think is going on here is either she doctored it herself or her due diligence into the election lawsuits and her statements was just doing Google searches or people sending her things, and she just took it at face value without any investigation or verification whatsoever. As the only thing I can think happened here. Again, if she had verifiable facts and evidence, she would have produced it. Why wouldn't you produce it? There is no gotcha in court, and she would know that. Dominion also alleges that Powell had a hand in drafting the declaration she touts as evidence of her claims. For example, Dominion alleges that the military intelligence expert, quote, who was the source for one declaration, has admitted that he never actually worked in the military, neither in military or never actually worked in military intelligence, should I say, that the declaration Powell's law firm drafted for him was misleading, and that he's now trying to backtrack on it. Dominion further alleges that after the source's recantation, Powell claimed that the declaration was actually from a different anonymous source, And she did so instead of investigating whether there was a reason to doubt the truth of the original source's claims. So that's pretty terrible lawyering, if I've ever... I mean, we've seen lots of terrible lawyering on this channel, Richard Leibowitz, but this is pretty terrible lawyering. Either she is just totally wantonly negligent, recklessly negligent, or she's deliberately not verifying the information, willfully blind to it. As for the other anonymous declarations proffered by Powell, Dominion alleges that they bear distinct signs of having been drafted by Powell herself. The court agrees certain sections in 2 of the declarations are almost completely identical. And we saw this in the Hex box, the Hex dice box case from Elderwood. The declarations they drafted in support of, or the declarations that were submitted in support of their secondary meaning trademark application, they were all pretty identical. And that was suspicious. More generally, Dominion alleges that the declarations provided no facts to support Powell's claims that Dominion flipped, stole, weighted, or injected any votes into the U.S. election. For example, one declaration says that vote counting was abruptly stopped in 5 states using Dominion software, and that at the time Donald Trump was significantly ahead in the votes, and that when the vote reporting resumed the very next morning, there was a very pronounced change in voting in favor of the opposite candidate, Joe Biden. The declaration provides no factual support for the proposition that Dominion had flipped votes from Trump to Biden, and it certainly says nothing about Dominion having been created in Venezuela. A second declaration provides even less support. While it mentions Smartmatic, it says nothing about Dominion or even a U.S. election. Dominion further alleges that Powell's expert reports are inherently unreliable. As a formal federal prosecutor, Powell had good reason to doubt their veracity. In particular, it alleges that one expert was involved in a recent fraud case where the judge ordered the expert to pay more than $25,000 after finding that she, the expert, violated consumer protection laws by misspending money she raised and soliciting donations while misrepresenting her experience and education, and that another, expert, was found to have provided materially false information in support of his claims of vote manipulation after referencing locations in Minnesota when alleging voter fraud in Michigan. That expert also publicly claimed that George Soros, President H.W. Bush's father, the Muslim Brotherhood, and, quote, leftists, helped form the, quote, deep state in Nazi Germany in the 1930s, which would have been a remarkable feat for Soros, says the judge, because he was born in 1930. Dominion also alleges that a third expert had been rejected by another federal court for his sheer unreliability, and a fourth has declared under penalty of perjury that there was a pattern of improbable vote reporting in a Michigan county. That does not exist. According to Dominion, an experienced litigator like Powell either knew or should have known about these grave problems with her expert's reliability, and thus she must have entertained serious doubts as to the truth of her statements, or at a minimum acted with a high degree of awareness of their probable falsity. Dominion also alleges that Powell cherry-picked and took out of context statements regarding general concerns about election security made by Professor Andrew W. Appel, or Apple. According to Dominion, Professor Appel's research regarding election security is reputable, but concerns a decades-old machine not designed by Dominion and not used in the 2020 election in any of the swing states challenged by Powell. Indeed, Dominion alleges that Professor Appel stated that he has never claimed that technical vulnerabilities have actually been exploited to alter the outcome of any U.S. election, and that no credible evidence has been put forth that supports a conclusion that the 2020 outcome in any state has been altered through any technical compromise. A reasonable juror could conclude that Powell's reliance on Professor Appel's research, when he has stated there is no credible evidence of fraud, is evidence of at least reckless disregard. Dominion argues that its allegations regarding falsified documents, inherently unreliable sources, misrepresentations about other evidence, and Powell's shifting positions reflect actual malice. It also argues that Powell had reasons for this conduct to raise funds, to raise her public profile, and to curry favor with President Trump. Powell argues that Dominion has no facts to support these claims, but Dominion alleges that Powell repeatedly solicited donations to her law firm and her company DTR while making her claims. That President Trump pardoned her client, Michael Flynn, on the same day she filed her first lawsuit challenging the results of the 2020 election, and that in November of 2020, someone purchased the website domain SidneyPowellForPresident.com, which that is kind of a speculation, but domains can be purchased without knowledge of who purchased them, so they're going to find out in discovery who purchased SidneyPowellForPresident.com and if that was connected to the motivations for those lawsuits. While it is true that evidence of ill will is insufficient by itself to support a finding of actual malice, Dominion has proffered much more. For the reasons discussed, Dominion has adequately alleged that Powell made her claims knowing that they were false, or at least with serious doubts as to their truthfulness. That doesn't mean that Dominion wins the case as to Powell. It means that they've cleared the hurdle of the motion to dismiss and will now be allowed to fully litigate their lawsuit. Let's talk about Mike Lindell. As for Lindell, Dominion contends that his claims were so inherently improbable that only a reckless man would have made them, that he intentionally disregarded evidence of their falsity, that he relied on obviously unreliable sources, and that he made his claims in accordance with a preconceived narrative that he constructed for financial gain. Like Powell, Lindell argues that Dominion has failed to allege actual malice because he has evidence to support his claims, and because he has never expressed doubt as to their truthfulness. But the majority of the evidence to which Lindell points is outside of the complaint, and the court cannot rely on this information at this time. In other words, Mike Lindell says he has evidence, and in his motion to dismiss, he didn't include it. Why you would have evidence that would set all of these lawsuits in motion, these election lawsuits, and you would never present it even after even as the lawsuits are failing, I don't know. Why would you do that unless it is a massive scam or grift? I can't understand. I, as an attorney, cannot go to court and allege my client has been injured in some way caused by a defendant and then never present the court with the evidence of the cause and the damages and the injury and all that, and expect the court to rule in my favor in any way. So the only reason you would do that is if you weren't using the lawsuits to adjudicate claims, but rather using it as propaganda to support your narrative, which is not, of course, what the courts are meant to do. But if you have the ability to gain financially from that, that's motive to do that, I guess. It sounds so unbelievably unethical to me that I honestly can't believe that we're here. I feel like I'm in like a Rick and Morty alternate dimension, like something clicked and I'm in a different dimension and my brain just can't wrap my brain around the weird situation that we're in. But here we are. Dominion alleges that Lindell has stated, among other things, that Dominion committed the biggest crime ever committed in election history against our country and the world, and stole the 2020 election by using an algorithm to flip and weight votes in its machines, that Trump received so many votes that the algorithm broke on election night, that Dominion's voting machines were built to cheat and steal elections, that a fake spreadsheet with fake IP and MAC addresses was a cyber footprint from inside the machines, proving that they were hacked, and that Dominion's plot was kept under wraps because the government had not really investigated claims of election fraud due to then Attorney General Bill Barr becoming corrupt and having been compromised. By the way, whenever you hear somebody refer to the government, that's automatically sus, because the government of the United States is a federal government. It's a federalist structure. You have a union of sovereign states. And yes, the Constitution enumerates some dozen or more powers that the federal government has over the states. But you have to talk, when you say which government, you have to say which government when you talk about the government doing something wrong. Was it the federal government? Does the federal government control the states? Does the state control the counties? They do have some control, but these are all separate entities. Yes, they can be working together, but because there's so many of them, tens of thousands of precincts, there would have to be pretty massive coordination for something like that to be true. So you can just summarize it all as the government and then use your propaganda to grift people out of their money is where I'm going with this. As a preliminary matter, a reasonable juror could conclude that the existence of a vast international conspiracy that is ignored by the government, but proven by a spreadsheet on an internet blog, that is so inherently improbable that only a reckless man would believe it. But Dominion also alleges other facts that make those claims even more obviously improbable, including 1. Public statements by election security specialists, Attorney General Barr, numerous government agencies, and elected officials. 2. Independent audits. And 3. Paper ballot recounts that disproved those claims. Dominion also alleges that Lindell was made aware of that countervailing evidence in Dominion's retraction letters. But instead of reconsidering his claims in light of the mountain of evidence against them, he doubled down and dared Dominion to sue him. To be sure, a demand letter that is ignored without more does not demonstrate actual malice. I want to back up a second. I forgot about this part. Mike Lindell did dare Dominion to sue him, and he said that all of the evidence would come out if he could get Dominion to sue him, get past a motion to dismiss, which is weird because if he wanted Dominion to sue him, why would he try to get rid of Dominion's lawsuit? Because what he said was he wanted to get to the discovery of evidence, if I recall this correctly. And that discovery of evidence goes two ways. It's the discovery of relevant evidence, and both parties can request from the other party any evidence that makes the plaintiff's claims or the defendant's defense more true or less true. That's the standard for relevancy. So that's everything that's relevant to these claims. That will be their statements. That will be their evidence. Dominion will very likely request from the defendants the evidence to support their claims, and then they have to produce it. This isn't another opportunity for them to just dismiss their case and then never present the evidence and say that they tried. This is where they have the chance to produce the evidence, and they will be required to do so or suffer that adverse inference potentially from the plaintiff and the court. If they can't produce the evidence, then an inference can be made that the evidence or lack of it is adverse to them, that the defendant's defenses are not true or would not withstand scrutiny. So this is what Mike Lindell wanted, and now he doesn't want it anymore. He's filed a motion to dismiss. Fortunately, the complaint survives the motion to dismiss, and now we will be going forward with that discovery of evidence in both directions. Back to actual malice. Here, the complaint rests on much more than Lindell's refusal to retract his statements. It also alleges that Lindell recklessly disregarded the truth by relying on obviously problematic sources to support a preconceived narrative he had crafted for his own profit. Moreover, Dominion alleges that the evidence on which Lindell did rely contains glaring discrepancies, rendering it wholly unreliable. Lindell, like Powell, relied on a forensic expert who had provided materially false information in support of his claims of vote manipulation, and who had claimed that George Soros, President H.W. Bush's father, the Muslim Brotherhood, and leftists all had a role in forming a Nazi deep state in the 1930s. As for the spreadsheet Lindell tweeted as evidence that President Trump got around 79 million votes and 60 million for Biden, Dominion alleges that the spreadsheet is obviously fake. The This is one of my favorite parts. In particular, the complaint alleges that although the spreadsheet purports to list IP addresses for election hackers and their targets, the listed target IP addresses are actually the addresses for the website of a county in a swing state and not for a voting machine or a device. And according to Dominion, the MAC addresses, if you're not familiar with what we're talking about, IP addresses and MAC addresses are used to communicate on the internet. The IP addresses are assigned. The MAC addresses are the individual device addresses. So your computer will have a MAC address, your phone will have a MAC address, and those are traceable back to a manufacturer and a type of device. They're assigned in groups and blocks, so certain devices get certain prefixes, etc. So listen to this. The MAC addresses in the spreadsheet, which should identify the specific devices involved in the purported hacks, are not MAC addresses that exist. So these are not MAC addresses that actually have been issued to devices. As for Lindell's purported profit motive, Dominion alleges that Lindell knew that appealing to Trump supporters would be good for business, and that his true motive is apparent in the repeated tying together of his election fraud claims and promotion of MyPillow products. Like Powell, Lindell correctly notes that allegations of a defendant's ill will or profit motive, without more, do not satisfy the actual malice standard. But again, Dominion has alleged more. In addition to alleging that Lindell's claims are inherently improbable, that his sources are unreliable, and that he has failed to acknowledge the validity of countervailing evidence, Dominion has alleged numerous instances in which Lindell told audiences to purchase MyPillow products after making his claims of election fraud, and providing MyPillow promotional codes related to those theories. In totality, it has adequately alleged that Lindell made his claims knowing that they were false or with reckless disregard for the truth. MyPillow argues that Lindell's statements cannot be imputed to it. In other words, Lindell and the company are separate and MyPillow is not part of this. But a corporation may be liable for an executive's conduct when the executive was acting within the scope of his employment and in furtherance of the company's business, says the court. With respect to Dominion's deceptive trade practice claims, Powell argues that she cannot be liable for deceptive trade practices because Dominion was not alleged or has not alleged that she was engaged in trade and commerce of goods. She points to a single case. Law school students, listen up. When you make such powerful claims, you need to back them up with your case law. That's what convinces district judges. You want case law from the Supreme Court, because that's going to be your strongest precedent. You want case law from your applicable appeals court, so whichever circuit you're in, or if you're in a state, the state appeals court or Supreme Court. If you can't get those direct precedential cases, then you can point to dicta or you can point to persuasive cases that would be other district courts, other appeals court decisions. That's still something you can rely on. You don't want to point to only one case. That the judge will look at that and wonder, why is there only one case, unless this is an unsettled area of law or a new area of law. She points to a single case in which the court granted summary judgment to a defendant on a deceptive trade practice claim when the defendant was engaged neither in the business of selling or distributing a substance at issue, nor in the business of selling or distributing products similar to those distributed by plaintiffs. But the court reached that conclusion after only after distinguishing other cases in which the defendant had a financial interest in the promulgation of its statements, which means that in that case, the judge also discussed the cases that overcome her argument, which is pretty dumb to present an argument where the very case you're citing overcomes your own argument. When such a statement, when such an interest, a financial interest exists, there is no requirement that a defendant be engaged in the trade and commerce of the goods at issue, says the judge. Dominion has pled that Powell had a financial interest in the promulgation of her statements. Lindell, in turn, argues that Dominion's deceptive trade practice claim is merely an attempt to avoid the requirements of the First Amendment. but Dominion has satisfied those requirements, and the Minnesota Deceptive Trade Practice Statute expressly contemplates that conduct might be actionable as both a common law tort, which means we don't need a written law, it might be case law, and under the statute, the written law, by providing relief in addition to remedies otherwise available against the same conduct under common law. Then the court goes into jurisdiction, which we're going to skim through or even maybe skip over entirely. Personal jurisdiction is the court's ability to have jurisdiction over your person. You need the court to have subject matter jurisdiction as well. This is where the court determines that the long-arm statute or minimum contacts for specific jurisdiction do apply to people who either live in the District of Columbia or have caused tortious injury to a plaintiff in the District of Columbia, etc. And rather than go into a detailed discussion of jurisdiction, we're going to skip ahead. We've been at this for nearly an hour now. So the court does determine that Powell and Lindell and Guiliani, I don't think Guiliani attacked it, are in the correct venue, and the case will not be dismissed for lack of jurisdiction because of that. And that's the end of the thing. The court then concludes, for the foregoing reasons, the court denies defendants' motions to dismiss in full. An order will be entered contemporaneously with this memorandum opinion, and that was yesterday. So yes, I agree with my various YouTube lawyer and internet lawyer colleagues who have evaluated this as well. This might not be the winning of the case, but it is a very high hurdle to clear. If you've cleared this hurdle, the rest of the hurdles are lower hurdles. So unless Dominion messes up their case, I feel like they're on the path to winning this case. Now, they do still have some other hurdles to clear. Defamation requires proof of damages, so they'll have to point to money that they lost, that those losses were caused by defendants' defamatory statements. And of course, they still have to have an adjudication on whether these statements were defamatory or not. But again, because the defendants filed a motion to dismiss, we already had to have an evaluation of whether these statements are factual, yes or no. And we've already seen now 9 months of election litigation, or rather 9 months after the election, and with all of that election litigation, no one has come forward with the evidence to support these statements of fact. So my conclusion, which admittedly has not been proven in a court of law yet, but my conclusion is that these statements of fact are not supported by evidence. The evidence does not exist, as the defendants have stated, and that is what I predict is the win for Dominion. I don't know how much money they'll win. It might be less money than the $1.3 billion that they're asking for, and I don't know how much each defendant is going to be ordered to pay, or what the judgments will be. That still has to be determined. Dominion will have to prove that. If they win, I assume they're going to go after attorney's fees as well. And I have no idea whether the defendants have the ability to pay. But what can happen here once there is a judgment, which I suspect will still be a year or more down the line. Once they do have a judgment, the judgment can be executed against the defendant's property. Wages can be garnished, bank accounts can be seized, and states will have slightly varying laws on how much you can garnish wages, what property you can attach to, and how much, and all that. But basically, if Powell or Guiliani or Mike Lindell, and that includes their companies, which includes MyPillow and Powell's DTR, the judgment could attach to those properties, and maybe someone has to either sell their company or the company has to pay, or maybe somebody's house can't be sold until the lien is paid. If it's $1.3 billion, and I don't think any of these people live in a $1.3 billion house, then once they sell their house, they would have to pay off the lien first. The lien would have priority over most other creditors. I'm not sure if the lien has priority over the primary mortgage. There's usually an order to these things, but yeah, this could be the beginning of financial ruin for the defendants. And in my opinion, that's the correct thing to do when someone uses your company to make their own profit on a pile of lies or baseless claims. It's ugly. It's sad. It's immoral. It's unethical, and I don't understand why they did it. Maybe this is a situation where even after paying the damages, they've still made more money, and so it was worth it to ruin whatever reputation they had. Maybe they don't think they're ruining their reputation with the people who care about them. Maybe they think they're ruining the reputation with the opposing political party, and therefore, who cares? I don't really understand the motivation. I think that there's potential for more damage than what they were actually able to make off of this. Maybe they have a plan. There is such a thing as a fraudulent transfer. You might try to transfer your assets or funds away from things that can be attached, that could be executed on. So maybe if you made $1 million off of these statements, you try to get that money out of the country before you can against that money. That can be considered a fraudulent transfer. So the fraudulent transfer, though, is a civil offense. It's not a criminal offense in most places. So I don't know this is going to go farther than money, and I really don't know how the plaintiff is going to recover the money. It's being reported recently that Giuliani is basically broke because he hasn't been paid for representing Trump in the election lawsuits. I don't know how true that is either, but that's what's been reported. So, long story short, this is a very powerful lawsuit. It has the potential to go all the way, and especially Mike Lindell, but also Giuliani and Powell will now have yet another opportunity to provide the evidence of the basis for their facts. And if they can't produce it, or if those facts are decided false by the jury or judge in a bench trial or summary judgment, then that's just yet another nail in the coffin of these election lawsuits. Every once in a while, I see someone make a comment. There's probably some people in the chat, I haven't looked, and some people come onto the Discord, or some people will say on Twitter, oh yeah, there's lots of evidence. And I'm like, fine, if there's all this evidence, no one would want to see it more than me. I know it's a hyperbolic statement, but I'd be right there, in the front of the line. I want to see the evidence, and if there was massive election fraud, I would want it to be corrected. I've voted for both Republicans and Democrats in my lifetime, and I don't have a problem with voting for a meritorious candidate on either side. I consider myself an independent voter, but recently, one particular political party has shown a lot more crazy activity, and I'm not really comfortable voting for the Republican side and until I see a candidate that has more ethics than what has been happening recently. People who support these baseless election lawsuits like Trump or Lindsey Graham or Mitch McConnell, there's just no, there's no way I can believe that they sincerely think that those things happened. I think it's people joining one message because they think they'll lose too many voters if they don't follow the craziness down the rabbit hole. But that's what that is. This is the Dominion lawsuits against Powell, Giuliani, and MyPillow and Mike Lindell, and they're going forward. So I will follow that. This will be a playlist for the election lawsuits here on my YouTube channel, and subscribe and like and comment. So I really appreciate you all. Let's see, there's 718 of you here right now. That's pretty awesome. And I want to thank our supporters. We have Patreon supporters who give the channel $50 a month or more. John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, Brandyn, Abel, ShadowTycho, RDHDragon, Earthbound Star, PureMagma, Drew Hart, and Eric Tams. We also have what looks like some Super chats. Goliath Cleric, thanks for this stream. Thank you for the $5. What do you think will be the biggest hurdle for Dominion to cross to win since they survived the motion to dismiss? I think I answered that question, but to re-answer that question, they will now need to actually get the jury to agree. That's about the biggest hurdle they have to cross from here. Physicist, thank you for the 15. I don't even know what that symbol is. Wow, I can send money now. Thanks for the stream. You're welcome. And thank you to all of our supporters on patreon.com/ljfrench, sponsors.com/law. You can help keep the channel going by supporting us there, subscribing on YouTube, becoming a member on YouTube. We're also on Linus Tech Tips float plane service as well. And I really appreciate you all coming. I'm going to let you go now. Have a great day. Love you all. Bye.